and welcome to the debate. I'm your host, Maqbool, with you at PTV WORLD. In today's show, of course, we will be taking a look at the political situation of the country, of course, with reference to what is going on in the Supreme Court that is all set to announce its decision on the Punjab Assembly Deputy Speaker's ruling around 7:30 p.m. today, which is just about 20 minutes from now. So hopefully we're going to be able to see once and for all what the Supreme Court actually decides on this particular case, especially the confusion with regard to the head of the party and then of course the parliamentary party, and whether or not the decision by the party head is going to be of consequence to the counting of votes in the elections of Punjab CM. That is going to be of course something that we will find out soon, but we will try and discuss so far what has happened with regards to the PDM's demand for a full court, which was earlier denied by the Supreme Court, saying that there hasn't been any clear legal grounds given with regards to how it is important or necessary, in fact, for a full court bench to be formed regarding this particular case. So we're going to try and explore that in further detail, why that wasn't done so and how there was no a legal validation according to the Supreme Court given for the Supreme Court to come to this particular decision. And then of course, following this decision that had come out regarding the full court bench, the ruling coalition's announcement to boycott the three-member bench that is now hearing the case regarding the Punjab Assembly Deputy Speaker's ruling. So we're going to try and see what this means in terms of the PDM stance, and then moving forward regarding the decision that is going to be announced soon, whether or not that is going to be accepted if the three-member bench is boycotted. And then of course the kind of details that we're getting from the Supreme Court as well with regards to the discussions that are being held, especially regarding the meanings of the terms a parliamentary party and the party head, and how whether or not these can be termed equivalent in terms of the consequences of such decisions. So we're going to explore that in further detail, and for this and more, of course, as always in the studios, I have with me Farrukh Pitafi and Raja Faisal. And to talk more about this particular case and its ruling that is going to be announced soon, we're going to also be having online Barrister Asad Rahim Khan. He's a legal expert, and we're also joined by Sardar Balak Khosa, who is an advocate of the Supreme Court. Thank you very much, gentlemen, for being with us and being a part of the debate. I'll start with you, Mr. Khosa. We have discussed this at length in our previous shows as well, and tried to understand what really is being taken into account and what really is being deliberated upon in the Supreme Court. It seems that it all still boils down to the question of whether or not the call by a party chief and that of the parliamentary party can be termed equivalent, since of course Article 63A only mentions the parliamentary party, and whether or not any sort of contradictions or precedents exist on account of such matters. So considering of course that we're going to be hearing shortly the Supreme Court's decision as well, what do you think in terms of what has been deliberated upon and spoken about so far in the courts, whether or not the stance regarding the parliamentary party and that announced by the party head is one and the same?
Bismillah ar-Rahman ar-Rahim. Allahumma salli ala Muhammad wa ala Muhammad. Very good evening to all of you. And yes, we, as of the readings of this case, we are learning every day, not only the question of law, rather what in the petition Chaudhry Parvez Elahi has demanded, and where the court is heading towards, number 2 and number 3, where the parliamentary parties, the grand government alliance is heading towards. So these are 3 questions which needs to be seen and on a very serious note. I think so that is one of the reasons that Supreme Court is taking all the aspects with a very serious thought, keeping in view the constitution, the domain and the powers of the Supreme Court of Pakistan as per the Constitution, Islamic Republic of Pakistan. The first question was that the Speaker, he has accessed his powers, number 1. Number 2 is that whether Supreme Court of Pakistan can have a trustee chief minister where it is written in the Constitution, Islamic Republic of Pakistan. Number 3, it seems that it is like a war taggle between the Supreme Court of Pakistan and the parliamentarians, the coalition government parliamentarians. where
All
they
right,
are
let's talk more about that as
asking
well. And
for.
let me come to Asad with regards to the decision also that has been announced with reference to the full court bench not being something that is deemed necessary by the Supreme Court for this particular case. The Chief Justice had earlier also mentioned that the full court bench sits on more complicated cases, and perhaps this one does not deem to be as complicated as that. But what other factors do you think are coming into play with regards to this decision? Because it also means that no real legal grounds were presented to the Chief Justice as well.
And Asad, could you also actually address the concern about or the question how this decision to boycott the proceedings by lawyers of one party actually play out in the court, whether it is going to have any impact at all on how the judgment is going to come?
Ji, thank you for having me, Sanat and Farrukh Saab. The main contention of this entire case was, has the Deputy Speaker issued a ruling that is in light of Article 63A, and is it constitutional or not? Now, as regards the PDM's decision to boycott these proceedings, I fear it is a rather convenient juncture after you have already presented your arguments, you have already put forward all of your legal points, you have been heard. And that also means that materially there is nothing to actually distinguish your case from any other. Because you've been given a fair opportunity, because all of your arguments have come across, to say at the 11th hour that you require instead a full court would also mean to create a precedent in which any petitioner can the next day rise and say that they would require a bench of their own choosing. That's the first point. The second aspect is that there was no such full bench when Mr. Suri's ruling was deemed, and rightly so, unconstitutional, and the parliament was restored. There was no such full bench when the same persons were acquitted during the Hudaybiyah proceedings or when their bail was accepted at the Supreme Court level. So to be able to controversialize or delegitimize the same judges again and again, I fear is very, very detrimental to Pakistan and to our legal system, whether it be the PTI saying this is part of a conspiracy, or whether it be the Pakistan Muslim League Nawaz and affiliated PDM parties saying that they do not have confidence in this court. As regards the original question as to whether there should be a full court or not, a full court, sir, is for complex constitutional matters or where there is a conflict in precedent. Neither of those two conditions arise right now. In fact, it's a fairly simple, fairly black and white question. Can you vote according to the directions of your parliamentary party or the party head? Was Mr. Mazari's ruling...
Could you give an example of a complex question as well, just so that we know what exactly we are dealing with right now?
An interpretation of 63A, should it be considered as complicated?
Certainly. A complex legal question is the case in which an actual full court was constituted, which was District Bar Association, Rawalpindi, PLD 2015, Supreme Court, page 401, in which the judgment had to deal with the question of whether or not Pakistan accepts or recognizes the doctrine of salient features as regards its constitution, and as a result, whether it can enable military courts or not. And this was a question that required all 17 judges, because they were going to be breaking new ground, and the only precedent that existed beforehand had to do with different legal questions in Mahmood Achakzai and Zafar Ali Shah's case. So that's an example of a complex legal question. As regards the interpretation that Raja Saab said of Article 63A, Article 63A has been interpreted threadbare in the previous judgment. I personally had a different understanding. I think in a parliamentary system, the backbencher is paramount, and if a person decides to dissent from the party line, his vote should be counted. In any event, the Supreme Court decided otherwise, but even within that judgment, nowhere have they said that this is the party head's prerogative. They have again said that this has to be in accordance with what the parliamentary party decides. So, long answer to your short question, this is not rocket science.
Right. So does this mean that in the event that the parliamentary party and the party head come to different conclusions or have different stances, then that particular case is going to have a completely different interpretation in itself, or it has to be aligned with the parliamentary party for the courts to be discounted?
It has to be aligned with the parliamentary party. That is what Article 63A says. The party head only comes in at the stage of defection. This is the plain meaning of the word. If our framers wanted that the party head decide, then they wouldn't have used the expression parliamentary party in the first place. The two expressions are not interchangeable.
Yeah, Khosa Saab, if we look into PDM's stance, of course they have boycotted today's whatever the ruling comes out of it. Can we expect from them to go against this ruling, today's ruling, whatever it is coming out today? And if so, then would they be seeking a different sort of bench for that?
And whether or not boycotting these proceedings will have any impact on their acceptance or rejection of the decision?
Well, yesterday I was there in the court of law, and from both sides they had their lengthy arguments, and especially the Supreme Court of Pakistan, they have said so that Article 69 is going to be hit by this court because you have no authority. These are the internal proceedings of the parliament. So to that question, Supreme Court clearly and loudly said that this question of law has already been decided in our judgment in the presidential reference. So that was gone. And then they said that this is not a case where because the Supreme Court is definitely going to jump in where there is a violation of the fundamental rights and the people who make the constitution, they have something done wrong about our judgment, because the Deputy Speaker has loudly and clearly said so, that I am going to implement the judgment of the Honorable Supreme Court of Pakistan. They said it might be his misconception, and we are going to correct that. So this is the case before us, because Supreme Court has never exactly said so. It's going to be the party head or the parliamentary secretary, the leader of the parliament. So they have distinguished it that it is going to be the parliamentary head. In this case, even Supreme Court has said so, that had the leader of the party has written any letter to the directions to the parliamentary head or to the 10 members of the provincial assemblies. So this question was not answered by the councils. So then the Supreme Court said, then why don't you argue on the merits? So they said we need a larger bench. Absolutely, it is correct that larger bench is needed there. Where there is a big question of the fundamental rights being infringed, as the military courts has no nexus in the Constitution of Islamic Republic of Pakistan dealing with the cases of the people of Pakistan. So that judgment is distinguished. And even in the judgment of the General Pervez Musharraf versus Iftikhar Muhammad Chaudhry, so that judgment was at a larger scale to be seen. But in here, that what I said. So,
earlier, when you were flagging the questions that have arisen during this hearing or this case, you also mentioned the trustee chief ministership, right? Now, I got the impression. I got the impression that somehow this is also something that is being questioned in the court. I don't know whether that is the case or not, because it seems that the merits of the case are very clear. But just for the convenience of the audience that are watching you, does this term actually stem from the Constitution, trustee chief ministership? And if it does, where exactly is it? If it doesn't, is it not another way of legislating through legal proceedings?
I think so. Supreme Court has accessed their jurisdiction. They can only interpret law where the law is silent. They cannot introduce anything new. There is no word in the Constitution of Islamic Republic of Pakistan that trustee chief minister. It is the caretaker chief minister or the full-fledged chief minister. So Supreme Court has to be very cautionary dealing up with such questions of law, because even in the question of facts, question of law, this trustee chief minister does not exist. So that is why they have given a argument to the PDM that there should have been a larger bench, and even Supreme Court has today said so. Even the creation of the larger bench means September, because it's vacation which are going on. On vacation, there is a Rostam, the Chief Justice announces that these judges are going to go abroad. These judges are not available, and only these judges are available. So they cannot like put
Right.
the
Right.
biggest
Asad Rahim,
province
let
of
me ask you
this
another
country
question.
held in a bind without a
Right.
government, without a chief minister.
Asad, earlier you were saying that the constitution is very clear about the two terms, that is parliamentary party and the party chief. And then you said that it is clear that the role of party chiefs comes when you are about to disqualify people because of their defection. But with due respect, could you qualify this, because there seems to be a matter of agency. Who holds the agency? Is it the parliamentary party that should be voting in accordance with its own will, or then it should be following in accordance with the party chief's will? Because if it is the former case, then the people who got disqualified, 25 people, should they have been heard first and given further avenues to actually mitigate the consequences?
Well, I do feel that their vote should have been counted in any event, but the Supreme Court has settled that in another direction. But to come to your question, Farrukh Saab, the only qualification here is that I feel that our framers decided to create a balance, and that balance is eminently understandable, to take away from the dictatorship of the party head while also trying to curb horse trading. In trying to maintain that
my
balance,
question was
they
also
inserted,
that whether this nuance
Right.
is also codified in the law. Is it does
Coming-
it exist in the
of course it
constitution
is.
as well?
That, of course it does, sir. The nuance is manifest. The nuance is that in the very first line of Article 63A, there is no mention of the party head whatsoever. In fact,
Right,
as
but,
far as
but-
any direction,
Right,
Yes.
but Asad, but of course, the question is being deliberated in the Supreme Court for a reason that perhaps the nuance does not really exist, because it seems that there
Yes.
was an ambiguity that, or a loophole that
if you
existed.
don't,
that
if
is
you
why
don't
we're
mind
here,
my
right?
saying, if you don't mind my saying, Ji, I don't think there is that much nuance or that many or
Okay.
loopholes of that nature. There is an almost complete legal consensus, with the exception of the people who are actually representing these parties, that parliamentary party means parliamentary party. The party head has no linkage whatsoever, and this is from very ordinary students of the law like myself to very senior advocates of the Supreme Court across the board. But I'll qualify this further. The agency that Farrukh Saab is referring to is with a parliamentary party for a reason, because the parliamentary party is rooted in the legislature. They get to decide what members of parliament do, not by extension, possibly unelected party heads like Mr. Shujat Hussain or other people of his like. And there's one more aspect of this that is distinct from 63A. That is Article 130, sub-Article 4. That also very clearly says that in the second round runoff election, only the previous two candidates from the first round can carry over, which means the question of Mr. Shujat Hussain choosing another candidate never arose. And this is something that is manifest from the original Supreme Court judgment that said that the election on the 22nd of July had to be a second round runoff election. So with great deference to your question, this is not complicated. There is no nuance. This
But
is a
trust me,
question
we are
that is
not
being
deliberately
litigated.
trying to
Yes.
actually
Right.
complicate it. But one long short question regarding who is part of what, the organogram, right? We know that our parliament is bicameral. I'm talking about the federal parliament. And then we are told that the president is also, who is not a member of the parliament, also a part of the parliament. Now the question at this moment is also what constitutes a parliamentary party and what exactly is the organogram. Is the party chief an integral part of what constitutes a parliamentary party or not? Is it not a big question also? Why not actually mention it that the head of parliamentary party should decide, or will actually exercise this will or agency?
And Barrister Asad,
it is
does it matter that the the head of the party is member of that parliament or not, or sitting outside?
Absolutely, it does. You have seen political parties being remote controlled from Edgware in the United Kingdom. You have seen them being remote controlled from various other regions. We won't get into that right now. But to come to the original question, sir, again, we might be splitting hairs. A parliamentary party is what it sounds like, which is the collective. The collective means that all the members who are elected to the legislature sit amongst themselves and arrive at a conclusion. It does not mean automatic or mechanical substitution with the head of the parliamentary party. It means that you congregate, you decide, and yes, the head of the parliamentary party then gets to convey it to the rest of the members. That again is distinct from the party head. So I do feel that these are fairly
but we just want to also get another clarification, the cost of being repetitive, that if there is consensus among the parliamentary party and the parliamentary party comes to a particular decision, irrespective of whatever the party head's decision may be, or it doesn't have to be aligned with that, or even if there is any separation in opinions, the parliamentary party takes precedence. Is that what you're saying?
And very quickly, just to understand, because there are remnants of PTI in the federal parliament as well, right? And if they decide tomorrow to sit with the government or sit on the treasury benches, do you think that it will be considered defection, because at this moment they are the ones who constitute the parliamentary party?
Well, I think that's an excellent question. But again, that happens when political parties decide to forsake their parliamentary role and leave the legislature and allow it to be taken over by gentlemen like Raja Riaz and lead us to manifestly absurd situations. And this goes back to your original point also, which is to say that as far as the ruling itself is concerned, what legal constitutional questions you are seeing being debated in the Supreme Court are needless. The history of Pakistan is littered with very simple constitutional questions that were turned into elaborate legal wrangling to defeat the mandate of the majority. That is what has happened in the Punjab Assembly. The person who had more votes was kept out through a technicality that is being deliberated to no common purpose by our political parties. It's a sad day for Pakistan.
Right, absolutely. Khosa Sahab, when we talk about, of course, what Asad was earlier saying, it seems that the decision that is going to be announced shortly is very clear. Whatever we're talking about seems that it's pointing towards what the decision should be. Are you also of the same opinion that the matter is quite clear and the decision of the Supreme Court will be the same? Khosa Sahab?
There seems to be some kind of communication breakdown. Khosa Sahab, can you hear us?
Yes.
Yeah.
Well, I think so that it's the Supreme Court has made up his mind that it is the parliamentary head who has to make the communication, and he needs to tell in accordance with the rules of business of the Provincial Assembly to the Speaker that these votes should not be counted, and because if it is from there has to be a constitutional amendment, because 63B says it has to be the parliamentary head. But if you read along with the next paragraph, which says the party head, and what is the need for the party head? Then there is no need for the party head to make any decisions. So I think there is going to be a constitutional amendment regarding the same. And Supreme Court has said so very loudly and clearly that we are going to clarify in our judgment that this is not our judgment which the Deputy Speaker has implemented by discarding these 10 votes. So I think this is going to be an end to this constitutional crisis which are in the province of Punjab.
Yeah, Khosa Sahab, if we talk about Political Parties Order 2002, what does it say about the mode of communication that should be used by the head of a party to convey a message to member of the parliament who are sitting in the parliament or the parliamentary committee head? How should he be making sure that he conveys the message what he's having for his members in the parliament?
Right, and before you answer, sir, just let me
The law
enlighten
is
the
very
mood.
clear.
Sir, just let me enlighten the mood. Sana, you notice how every time our friend Faisal asks a question, he takes the name of the person who is going to be questioned twice. So it reminded me of a movie based on the life of Gabriel Garcia Marquez. Postman always rings twice.
Yeah.
So our postman keeps on ringing twice. Yeah. Qasas Saab, go ahead.
You see, it's the law says and the rules of business and the judgments which are being there in the field, and even the Chief Justice himself said so. If it is written by Chaudhry Shujaat Hussain to the parliamentary head, and same has been conveyed to the 10 members, if that communication is with you guys, if that communication is with you, if that receives the registered envelope, TCS, DHL or postage that is with you, the court is with you. But if not so, if it is not being delivered through the party head to the parliamentary leader, then our judgment is wrongly implemented.
Right.
Right, but very quickly, just now you actually brought up a new term, and that is the head of the parliamentary party. Is that term used anywhere in the constitution, particularly Article 63, sir? Khosa Sahab?
The constitution is silent, so that is why when the law was made, it was against the fundamental, it was rights, and nobody pointed out. Because on the one side you say it is the parliamentary head who has to correspond regarding the same. But the next paragraph says it is the head of the party. So it is silent where the Supreme Court is intervening. That is why the Supreme Court is intervening, because the constitution, there is ambiguity. It is shrouded in mystery. It is cloudy.
So, Barrister Asad, it means that whatever the ruling we are getting today, would it be used as a precedent in future as well?
That would go for all Supreme Court judgments, Raja Sahab.
But this obviously related to 63A. Obviously, we never had.
Certainly it would.
Right. Mr. Asad, when we talk about the ruling.
If I be allowed, I'll
Yes,
just add
Professor.
one more thing. For
Continue.
the larger bench, because they requested the judgment in which 24 members were disqualified, that judgment is also pending in the review petition before the Supreme Court of Pakistan. So they said if the review is accepted, meaning thereby those votes are going to be counted and they will be back to the parliament. So everything vanishes away. So this was one of the plea which they have taken, and then Supreme Court said, okay, if such like situation is going to happen, then let's the law its place.
Right.
But we cannot
before we
allow
head towards,
without
Khosa Sahab, before we
without
head
the
towards hypotheticals, I want to understand, in case there is a review petition and it is accepted for hearing, which bench is going to hear that?
A different one?
I'm sorry,
Khosa Sahab.
who is going to?
Hear that case, that review petition, if a review is accepted for hearing.
Yeah. So the previous position will be back, where the Hamza Shehbaz is a
Which
complete
judges
chief
are going
minister.
to hear that? The judges
Will
that
it-
actually heard the case before, or somebody else?
Will
The
it be
same bench, the bench.
Unfortunately, we're unable to hear Khosa Sahab properly, but we'll come back to you, Khosa Sahab.
Can
Mr.
Asad
Asad,
Sahab actually clarify
The
this
5
point?
members hear that
Ji.
review.
Yes, Asad, you can answer
The same judges who were in the original judgment will also be there in the review. Those are the Supreme Court rules. The Supreme Court rules and convention also demands that even the counsel have to be the same as the ones that argued the original petition before the Supreme Court.
Right. Azhar, when we talk about the ruling coalition's decision to boycott the elections, earlier also asked whether or not it's going to have any legal implications in terms of their acceptance or rejection. I understand once the decision comes out, it will be a part of the law, and there will be a discussion as to what the interpretation of Article 63A is. But with regards to the kind of narrative that has been circulating, especially the events of this particular year, the Supreme Court, of course, has come into the limelight quite a lot in terms of the political impact of their decisions as well, and then of course the way public opinion is also going to view it. Of course, regardless of the impact it's going to have on the decision, that remains in terms of the sanctity of the Constitution. But otherwise, as an institution, do you think that this is going to have any impact on the Supreme Court? Because the kind of narrative that was put forward regarding the full court bench is put forward in terms of how it was needed to remove any ambiguities, even though the ruling coalition said they believe in the neutrality of the judges, but they still wanted a full court bench. So does it anyway damage the Supreme Court's integrity in terms of the public opinion?
It in no way damages the integrity of the Supreme Court. In the same vein, when the other party alleged that they were part of a galactic conspiracy, it still did not damage the integrity of the Supreme Court. The Supreme Court's integrity is only damaged when they decide to arrive at political solutions or middle of the way solutions to what are essentially legal problems. This is the first boycott that I've heard of in which a petitioner goes to the courts, argues at length, concludes their arguments, and then at the nth moment decide to say, I proceed to boycott, and then walk out of the court. If that doesn't manifest their intentions, I don't know what does. This has no legal consequence on the judgment whatsoever. It has no consequence on the impact of that judgment, or what Raja Saab said earlier about its value as a precedent with regards to Article 63A, and it would be better for our political personalities to refrain from trying and failing at controversializing the courts, which is a tactic that is sadly displayed across the political spectrum.
And one more normative question regarding the perception and reality, and how political parties try to, drag the honorable courts through controversies. Should it matter to any judge or the honorable courts how a political party is trying to portray their decisions? Because in the end, it is not an elected body. So should it be actually concerned at all about its image?
And I also want to further get a clarification with regards to public opinion, and I understand the distinction that you made, but do you think that that's also something that the general public understands, that this is not an intervention in the political matters of the country?
I feel that the general public is far more intelligent than the forces that have been running this country for the past 7 decades. They understand intention, they understand goodwill, they understand which people want to fight for this country and its betterment, and which ones are just bent on perpetuating themselves. The public has voted for everyone. It has voted for Muslim League, Tehreek-e-Insaf, Muttahida Qawmi Movement, the far right, the ANP, in search of some sort of a better political settlement, and they have never disappointed you. But to come to the previous question, yes, the court should be concerned. It is famously said about the judiciary, they have neither sword nor purse. They have no army to enforce their orders. They have no elected legislature from which they derive their power. Having said that, though, I fear that the prerogative lies with our political personalities and our certain undemocratic forces from not delegitimizing the judiciary, because the judiciary by itself is quite defenseless. So rather than trying to bring them down in the public eye, it would be best to accept the judgment and try to create an enduring political settlement between yourselves.
Right, Asad, no political party or no political agent ever wants to give up any kind of ace if it has it in hand. If they have this victim card, they are going to play it. You know it, right? Sir. Regardless of what ethics actually dictate. But let us come back to the merits of the case at this moment. And let me ask you, because there seems to be a consensus that there is some sort of ambiguity in the language of the said law, particularly 63A. Can we also hope or expect that the Honorable Court will send the matter to the Parliament to legislate upon and to clarify the language later on as well? We have seen such precedents in the past.
Well, sir, because the matter is sub judice, I wouldn't want to say whether they can incline towards that outcome or not. Is it a possibility? Certainly. But it would be better that, as far as Article 63A is concerned, which was elaborated upon by a legislature after the 14th Amendment and the 18th Amendment, so that's 2 rounds of the Parliament sitting and deciding what 63A should be, it would be best for the Supreme Court to just clarify what it means in law rather than sending it to Parliament for a third round.
Yeah, my concern is regarding 18th Amendment. If you remember how it was passed, there was a big committee or comprising all political parties, but it debated outside the Parliament. And later on,
True.
when it came to the floor of the Parliament, there was hardly any discussion there, right? It was just passed in a heartbeat. So, is it not important that if there is an ambiguity, because interpretation is temporary, language is permanent, you could actually ask to revise the language as well?
Sir, I think there is a possibility, but it would be best that when all your political stakeholders are asking you for a clarification of law, that the law be clarified, so that we're able to advance towards some semblance of stability. If, and this is again, because these proceedings are sub judice, whatever happens in the court should remain confined to the court. In the hypothetical you speak of, though, if this decides to be lobbed back into the realm of the legislature, and it is entirely the legislature's prerogative, I'm not taking that away from them, it will, though, lead to further uncertainty, and this will elongate this process. Right now, the core question is the current government that has been formed in Punjab a legal entity or not? And we need to get beyond that now. It's been 3 months.
Right. And so regardless of this being taken to the Parliament, the question is going to be answered. Yes?
Absolutely.
Right.
Temporarily. In the long run, of course, it can change, right?
Again, sir, absolutely.
No, but you seem to be under the impression that I'm asking you to comment on what is going on within the Honorable Court. I am not. I'm just talking to you
certainly,
as a citizen.
Sir, certainly.
Expectation of a citizen, nothing else. Yeah.
Sir, Article 63A, or rather the poison of defection, has been debated in our legislature as early as the late 40s. You will find Constituent Assembly debates from 1948. This then transformed into something else under Mr. Bhutto, was thrown out in 1985 in the General Zia Assembly, and then came back in 1997 by Mia Saab, and then was given more teeth in 2010 after the 18th Amendment. So will this change 10 years from now, 20 years from now? I have no doubt it will.
Right. Khosa Saab, do you think that whatever is happening in the Supreme Court and the clarification that is, of course, under discussion is a good, positive byproduct of whatever is happening politically as well, and will help in the way of defining the Constitution further and actually making sure that such political maneuvers, or what Asad was earlier talking about as technical manipulation, do not occur?
You see what? Where a matter of public importance is ever challenged before the Supreme Court of Pakistan, it is very clear in the that where the government fails, or where the legislators fail, or where the bureaucracy fails, or where there is something which is not there in the Constitution, a parliament, a government, a bureaucrat, or anyone who crosses the border and crosses the limit, where the Constitution is clear and somebody has overwhelmed it, taken over the Constitution, then the Supreme Court of Pakistan implements the law where the fundamental rights are being infringed. So their Supreme Court is only to implement the Constitution. Supreme Court cannot amend the Constitution. Supreme Court cannot override the Constitution. But where the Constitution is silent, where there is an ambiguity, as there is ambiguity in 63. So their Supreme Court has all the right to clarify it. And I may make it very clear to the people of Pakistan, for God's sake, and even the parliamentarians. Now we need to come out of the patchwork. We are having the patchwork on the road that does not prevail at all. We need to wrap up the system. We need to see, as in London, they have the Wolf's Amendment. Right. They change their entire system, keeping in view the issues, the problems of the people of UK. So we need to change now, keeping in view the issues which the people of Pakistan are having. So that's why we are going to now change the system. And for the people of Pakistan, I must say, we must see first Pakistan, then any political party. This is the only solution.
Right, Khosa Sahab, going back to the to your participation during the in this program in the past as well, I have this distinct impression that you actually believe in the supremacy of the parliament. My question, then concern actually, is that when you talk about the structure of Pakistani parliament, it is not exactly Westminster. The electoral process seems to be different from what goes on in UK, and that is proportional representation. Here the candidate's own prowess also matters. The problem at this moment is that when you look at how debates have been going on in the parliament and legislation has taken place, organically we don't see that kind of a push to properly interpret the law or to revise it, right? And that actually worries everybody who is looking at the parliament. Should, in this context, the Honorable Court not actually ask the parliament to do something to close this loophole?
You see, their system is absolutely, you're right, different from us. But unfortunately, after 1947, what is CPC? What is PPC? What is Contract Act? If these laws would have been so good, then the Queen must have implemented these laws into their country, into like in Canada, in Australia, in UK. These were the laws to get you changed. So that's why, and unfortunately, all of you will agree with me, when there is a constitutional amendments being made, it is so unfortunate. A section officer prepares the whole draft. For God's sake, now we need to come out of it. We need to grow up. We need to have educated parliamentarians, so who can make the laws, who can understand the laws, and who understand the problems of the people of Pakistan. And even the constitutional amendments has to be there without any ambiguity. So to save the time of the honorable courts, the high courts, the lower courts, the Supreme Court of Pakistan. So that's how the system is going to run now. We need to have a bigger, we all need to sit together, even if we don't want to see any political parties leaders face, but for a bigger cause, for the
we all need to sit together.
We need to sit together.
Yeah, we all need to sit together. Barrister Asad, just want to know from you whether Khosa Saab is right about it when he obviously emphasizes on the doctrine of the necessity. Are we expecting in today's decision that it would be reflecting the ground realities of today's Pakistan, looking at the obviously what people want right now, and looking at what economic situation Pakistan is right now in? Would we be expecting a decision that can serve Pakistan in a way that it was a doctrine of the necessity?
But the Supreme Court's decision, of course, is dependent on the constitution of public opinion.
And very quickly, Faisal, once again, for a second, I thought that you are inviting us all who are participating in this program to a party. But later on, you changed the direction, right? And you ended up talking about the doctrine of necessity.
Exactly, I did.
Yes, Asad.
Yeah, that's it.
Well, I think, sir, that as far as the doctrine of necessity is concerned, that expression should only be used in judgments when there is a war ongoing and there is some form of cataclysm that has approached. And by cataclysm, I don't mean what happened in 1958 or 1969, and you can go on and on. The doctrine of necessity is a doctrine that has been exploited again and again within our system. So I would certainly hope that expression does not manifest in the judgment. But I would again say, because it is sub judice, that I wouldn't want to say what it should be like or what it can be like. Having said that, I will again reiterate, this is not rocket science. This is a very simple legal question. Mr. Mazari used a Tamizuddin-esque form of legal wrangling to try and defeat the mandate of the majority. It has as little connection with the law as Mr. Suri's equally absurd ruling in April. Back in April, we did not hear about the need for a full court. We did not hear about the need for a national dialogue.
Actually, we did.
We did not.
Actually,
yes.
Sorry to cut
well,
you, but
all right,
Farrukh Naik actually went to the
well,
court and requested that there should be a full court. And I think this is the idea. This is the osmosis of idea. It is the origin that it came from them, that there should be, and then the Honorable Court didn't actually entertain that notion.
Well, then, Farrukh Saab, then the point is made yet again, that even if you did do that during Mr. Suri's ruling, it was turned down then, and it's been turned down again. Right. This is not something that requires this much complexity. Hopefully, we can go back to the principle we had, ironically, in 1993 with the judgment of Mia Mohammad Nawaz Sharif versus President of Pakistan, which says it is a fundamental right of every Pakistani to be governed by a parliamentary majority, not by a technocratic government, not by a grand national dialogue, not by some charter of economy, not by some technocrats in some room, but by elected representatives of the people, the majority of whom will actually govern you. And that's it.
Right. Thank you so much, Barrister Asad Rahim Khan and Sardar Balak Sheikh Khosa, for joining us and being a part of the debate, and of course for talking to us at length about these legal matters. Thank you very much, and that's all we have from the debate. Of course, the decision is still yet to come, but you keep watching PTV World to get more updates and news regarding that. We'll see you tomorrow at the debate, but at a different time, since now you're going to be seeing the debate at 10 p.m., but of course on Beyond PTV World.